Hello and welcome to our lecture this week. We're going to be talking about federalism, which you may have heard of. We've touched on it before. We've touched on it when we talked about the Constitution. But today we're going to talk about it in a little bit more detail. And those of you that are interested in history probably recognize this flag. This was from a cartoon that Benjamin Franklin published in the Pennsylvania Gazette in 1754. And as you can see, the idea here is that the colonies, you can see they're here, New York, Pennsylvania, New Jersey, Virginia, North Carolina, need to unify together if they want to succeed, or else they're going to end up like this snake, cut into parts and dead. And this cartoon was published at the beginning of the French and Indian War. At the time, the idea was for the colonies to unite against the French, but of course, during the Revolutionary War, it's going to change towards uniting against the British. Now, why did the colonies unify? Well, a couple big reasons that happened in the mid to late 1700s. The first was the French and Indian War, which was a war between Britain and the colonies against France and France's Native American allies. There were also Native Americans who were aligned with the British and the colonists as well. But they came together to try to protect their interest against the French. Later on, after the war ends, there's a need to come together again, this time to protect colonial rights against the British. And then, later on, when we get the Constitution, there's a need once more to come together to form a stronger national government. Now, why did all 13 colonies want to come together? One is they're too small to go it alone. Another is they all thought of themselves as being part of the same nation. In other words, they share a same sense of identity. They're all Anglos, English-speaking, similar culture, had much more in common than they had different. Now, federalism is not the only system. There are others. First is a confederal system, and this is a system under which there's a very weak central government, and states retain most of their authority. This is the system that existed under the Articles of Confederation. And you could also argue this is a system that exists, say, under the European Union right now. You have a very weak central government, but most of the power is still exercised by states or units of the national government. There aren't a whole lot of examples of this in existence today. Switzerland, with the canton system, is maybe the closest. The other end of the extreme would be the unitary system. This one's a little bit more common. In this system, virtually all the power is granted to the national or central authority. And states may exist, but they have very little to no power independent of the national government. And there's some examples of this today. Places like France or Japan or Ireland or Israel are all examples of unitary systems. The system we have, though, is federalism, or also known as a federal system. Federalism and federal system are used interchangeably. And this is a middle way. This is designed to maximize the benefits of both a confederal and a unitary system, and also minimize the drawbacks of each. So the idea here is to try to take the best of both worlds here. We want a central government that's strong enough to govern, but we also want states to retain some power and authority as well. Now, so what is federalism? It's power sharing between different levels of government. Federal government, state government, and local governments as well. So we have a government in Washington, D.C. We have a government in Nashville. They each have different roles, although sometimes their roles overlap. We also have a government in Roane County, and we also have a government in Harriman, one in Rockwood, one in Kingston. So different levels of authority here. In some areas, the states retain the areas of authority. In places like this, they can make the final decisions. In areas where power is delegated to the national government, though, then the feds get to make the final decisions. Of course, this is controversial because it creates questions about which level of government should do what. Obviously, this is a system where the federal government and state governments are both in a rivalry and in a partnership. This was an unusual system in 1787. Virtually all governments at that time were either confederal or unitary. And one of the reasons the founders set up the government this way was to further divide power. Remember, one of the biggest fears they had was that we might get a central government which might become too powerful. So the idea is to divide power wherever possible. Now, there are advantages and disadvantages to federalism. We got to talk about the advantages first. One is that it permits diversity. Tennessee and California are very different states. Cultures are different. People want different things. So it is fair that Tennesseans and Californians should both have a government that represents their interests, right? And that's going to look a little different. There's also the fact that local governments may be better prepared to deal with local problems. Obviously, you wouldn't want the federal government fixing potholes in your street in front of your house. Local governments are going to be better for that. Local, smaller, lower levels of government also create more opportunities to participate in government. You want to get involved in government? Run for office. You can run for a city council commission or county commission position, or a school board position. You don't really need a lot of money to do it. This is an area where money doesn't necessarily win out. You can go out and really a lot of times it just comes down to whoever knocks on the most doors and shakes most hands and kisses enough babies. So the doors are pretty open if you're interested in getting involved in local government. This also allows for more experimentation and innovation. We can look, if we say we have a problem with healthcare, right? We should look at the other 49 states and see what they're doing, see which states have the best systems, and try to emulate those systems as much as possible. So this is another advantage of federalism. We talked about this before. Some New Deal programs were directly copied by the states. Actually, the Affordable Care Act, which we have now, was based largely on a system that existed in Massachusetts in the beginning in the early 2000s. Also, the United States is a huge country, very diverse, lots of territory, lots of different people. States are different. They have different sets of needs and thus need different laws. Speed limits, for example. Speed limit in, say, East Tennessee, where it's mountainous and curvy roads, should probably be lower than it should be in North Dakota, where it's mostly flat and there's very little traffic. So federalism allows for all this. There are some disadvantages, though. One is that it can protect racial and economic discrimination. So, for example, by the mid-1960s, opinion polls nationwide indicated that most Americans were opposed to segregation. They believed segregation was wrong. However, there were some states where majorities still supported segregation, places like Alabama, Mississippi, Georgia, South Carolina. And thus, segregation continued in those states beyond the point at which nationwide public opinion had turned against it. If we'd had a unitary system, probably segregation in the Jim Crow era would have ended sooner. Local governments are not always better. People complain about national government, but, local governments can be corrupt too, or incompetent. And in fact, corruption at the local level is probably easier because if you're in D.C., you have lots of attention on you at all times. Most people aren't really paying much attention to what the county commission or the city council are doing. I mean, especially in smaller towns or counties, there may be one newspaper who sends one reporter to cover it, and a lot easier to get something by one person than it is, say, in D.C., where you have to get it by hundreds of reporters. Law enforcement may be unevenly applied, although this is not supposed to happen. It's probably a safe bet that if you drive down Roan Street, which is, if you don't know, the main drag in Harriman, if you drive through there speeding, if you have, say, New York license plates, all other things being equal, you're probably more likely to get pulled over than if you have Roane County license plates. Also, this can make it hard to maintain national unity and identity. So we saw the Civil War happened. Partly that might have been one of the flaws of federalism. Now, we got to talk about what the Constitution establishes. The federal government has these powers under the United States Constitution. Power to raise armies, to declare war, to establish rules for citizenship, the power to tax, the power to borrow money, and to regulate interstate and foreign commerce. They also have what's called the Necessary and Proper Clause. Congress shall make all laws necessary and proper, which is vague and elastic and has led to an expansion of federal power. Constitution delegates other powers to state governments. Originally, it didn't provide a list of it. Instead, it had the 10th Amendment, which says that everything not outlined in the Constitution is left to the states or to the people. Over the years, though, we have seen areas in which the states typically have the most power. One of these would be police powers, law enforcement. There is obviously federal law enforcement, the FBI, the DEA, but these are limited. FBI agents are called special agents because they have very special jurisdictions. Most crimes, most law enforcement, and most judicial proceedings happen at the state level, not at the federal level. Most crimes are state crimes. There's only a relative handful of crimes that are federal crimes. If you cross state lines, for example, it becomes a federal issue. Of course, through the internet, that's becoming more common. But still, even today, most crimes are at the state level. The states also oversee regulation, licensing, and marriage and divorce. You can't buy health insurance across state lines, technically. Also, professional licensing is usually done by state boards, so teachers, electricians, doctors, lawyers, beauticians, things like that, people like that, professions like that need licensing, usually get it from the state level. There is no national level for this, and obviously your driver's license is issued by the state too, and all other states will recognize it. Then there's areas where both the federal government and state governments have shared powers. Among these, this would be what are called concurrent powers, which means they're held by both the federal and state levels. Among these would be taxing, borrowing, spending, enforcing laws, establish court systems, regulating elections. You have to pay taxes for both the state and to the federal government, right? So there are areas here. In areas of shared powers, if there's a conflict between federal law and state law, then federal law will win out. The Constitution also puts limits on the power of both federal and state and local governments as well. Can't suspend habeas corpus, can't have bills of attainder, can't have ex post facto laws. Habeas corpus means right to know what you're being charged with and appear before a judge. A bill of attainder is when you declare someone guilty of a crime by, say, executive order or an act of Congress. The only way you can be found guilty of a crime is through due process, through the judiciary. And ex post facto laws, which means you can't enforce a law after it was adopted. So in other words, if a law goes into effect on January 1st, 2019, you cannot enforce it against somebody who committed the quote-unquote crime on December 31st, 2018. It's not a crime until the law goes into effect. States are also required under the Constitution to have Republican forms of government, which means no monarchy, no direct democracy. And states are also required to follow due process and equal protections, which the courts have ruled that states are required to follow. Now, relationship between the nation states, national law overrides state law generally. This is in areas where there is tension. In some cases, the federal government can preempt state laws. That means if it's an area of concurrent authority, which means, again, both feds and the states have authority in an area, national law wins out. Congress also has what are called implied powers. We've mentioned this, I think, before. These are powers not expressly granted in the Constitution, but added through the necessary and proper clause. One implied power might be the Air Force. The Army and Navy are both mentioned in the Constitution, but the Air Force isn't. Obviously, the reason is that planes had not been invented yet in 1787, so it's reasonable to assume, and thus implied, that a Air Force is constitutional, but it's not literally in there. But that would be a good example of an implied power of Congress. Sovereign immunity, can you sue the government? The answer is generally no, unless the government gives you permission to do it. Now, you might be asking why the government would ever give you permission to sue them. There's a few specific cases in which you are allowed to sue the government. One is you're allowed to sue government if they violate your civil rights, thanks to the Civil Rights Act. You're also allowed to sue the government if you are an employee of the government and you're subjected to unsafe working conditions, or you don't get paid, or the government doesn't follow their end of a contract. In those areas, Congress has passed legislation that allows you to sue the government. Beyond that, though, you generally can't sue the government, which is why if you want to sue the government, you typically sue the head of the level of government you want to sue. So in other words, if you wanted to sue the state of Tennessee, you would sue the governor. If you wanted to sue the federal government, you would sue the president. All right. Relationships among the states. We need to talk about this. States can enter into agreements with each other, but they have to be approved by Congress. Congress also has the exclusive authority to regulate commerce between the states. One of the problems of the Articles of Confederation was that states had created tariffs against other states, and of course this damages national economic growth. So the Constitution makes that illegal. Only Congress can regulate commerce between the states, not the states themselves. There can be no tariffs between the states. Agreements between two or more states must have the approval of Congress. This happens in areas where states share resources, like, for example, the Tennessee River flows through Tennessee, also through Alabama, also through Kentucky. So, obviously, if, say, Alabama started dumping pollutants into the Tennessee River and they flowed over into Tennessee, then that would be a problem. So in situations like this, the states have to come together and come to some kind of agreement, which Congress then will typically approve. Full faith and credit clause. This means states must accept court decisions made in other states. So in other words, if you're convicted of a crime or there's a warrant out for your arrest in Tennessee, you can't just go to Kentucky and be home free. No, law enforcement there will arrest you and extradite you back to Tennessee. Also, things like, this is one of the reasons that things like marriage licenses are recognized throughout the country. If you get married in one state, it's typically recognized in other states. Privileges and immunities clause. States must treat people from other states equally to their own residents. There's always been debate over what the role of the different levels of government are, and this goes back to the Federalists and the Anti-Federalists. You might remember, for example, that Hamilton wanted a stronger central government, whereas Jefferson wanted stronger state governments. Hamilton would have been more in the unitary government camp, whereas Jefferson would have been more in the confederal camp. Somewhere in between would be the system that we have. So the early history of the United States was mostly one of state-centered federalism. Nation-centered federalism did win on occasion. We did get the National Bank, for example. But for the most part, state governments did most of the governing, and the federal government was much more limited and hands-off. You also have to keep in mind, too, that we didn't keep huge military during times of peace. During this time, we didn't have things like Social Security or Medicare either, so the federal government was doing a whole lot less then than it is today. The Sedition Act was an act which was passed by Congress and signed by John Adams, which made it illegal to criticize the president. Jefferson argued in favor of a nullification act. He argued that states can decide for themselves which national laws they want to obey. So this is an example of extreme federalism, or extreme confederalism, I guess you could say. Does this still hold water today? The answer is no, but this argument he made is later on going to be the basis for secession and for the Confederacy. Supreme Court, through the years, has gradually shifted more and more power to the national government. Now, state and federal governments have come into conflict before. Civil War, obviously, is the most infamous example, but there have been others. During the presidency of Alexander, I'll get right in a minute, Andrew Jackson, there was what's called the nullification crisis. Jackson had signed into law a tariff, which was popular in the North because it protected northern industry, but unpopular in the South because it meant the South had to pay more for goods made in the North. So Jackson signed it into law, and South Carolina threatened to nullify it. In other words, they threatened to pass a law declaring the tariff would be null and void within the state of South Carolina. Jackson threatened to invade South Carolina and hang the leaders of this uprising against federal authority, one of whom, by the way, was John C. Calhoun, who was Jackson's vice president. But that's another story. He resigned and went back to South Carolina to support South Carolina. Ultimately, cooler heads prevailed and an agreement was worked out. Civil War came about largely because of slavery, but it also settled the issue of secession. Do states have the right to secede from the Union? The answer is Civil War determined no. Maybe settled by war, but not by law, but de facto it was determined not. Now, the Civil War was a sort of a high point of federal power over state power. After that, the national government stepped back again, and throughout the rest of the 19th century, up until the early 20th century, the federal government was pretty minimalist. And this is the era which we call dual federalism. And under this system, the national government is supreme in some spheres, but state government is supreme in others. This would have been, again, the era during the mid to late 19th century. National government is supreme in areas of foreign affairs, interstate commerce. State governments are supreme in intrastate commerce and in policy powers. This started during this time again. The national government didn't do much. There was no large standing army during times of peace. There was no Social Security, no Medicare, no Medicaid, no food stamp program, no national park system, none of these things. So federal government didn't do much. States had more power. This starts to change though in the late 19th century with industrialization and the Industrial Revolution. In 1887, the first federal regulatory agency was created, and that was the Interstate Commerce Commission, and it was designed to ensure that railroads charged fair rates to farmers. We also, in 1890, get the Sherman Antitrust Act, which outlawed trusts, which are essentially monopolies, which is what happens when one business controls an entire industry. We also get regulation of child labor. And in the early 20th century, in 1913, we get the 16th Amendment, which gives us a permanent income tax for the first time in American history, which I know so many of you are grateful for. Now, federal government in the 20th century is going to become more powerful. Senator Everett Dirksen of Illinois, for instance, famously quipped that the only people that are going to be interested in state boundaries are Rand McNally. Rand McNally's a map maker, by the way. What he's saying here is that the power is going to be at the national level and states are only going to exist as lines on a map. And it's certainly true that the balance of power shifted more to the national government in the last 100 years or so. And why has more power shifted to the federal government? One reason is the federal government does a whole lot more stuff today than it did 100 years ago. I mean, just in the last, 80 years or so, we've gotten Social Security, medical insurance, aid to education, welfare payments to the states. We've gotten Medicare, Medicaid. The national park system is a little over 100 years old, but within the 20th century, the federal government scope has increased greatly. We have 15 cabinet-level departments today. 7 of them were formed in 1965 or later, so in the last 55 years or so, the number of cabinet positions has almost doubled in number. We've also had big expansions of federal power, biggest ones being during the New Deal in the 1930s and in the Great Society in the 1960s. So the federal government takes a much bigger role than it has before domestically. This is also true internationally. Back in the 19th century, we didn't keep a large standing army during times of peace. We kept a small army and a small navy, and when we went to war, we would raise armies at that point, fight our wars. Then after the war was over, everybody would go back home, and the military would revert back to its small size. However, this is probably no longer possible in the world we live in. In the 19th century, if we were going to be invaded, a foreign power would have to raise an army, bring them over, or a navy, bring them over on a boat, which could take several weeks and then attack us. Today, we could be attacked from anywhere in the world within 20 minutes. In the age of nuclear weapons, it is probably necessary now that we have a permanent standing military. It's also important that we have intelligence, spies, things like that, and technology to keep us ahead of the other threats in the rest of the world. National security alone today counts for about a fifth of the federal budget. And of course, most of you have grown up almost entirely post 9/11. We fought major wars in both Afghanistan and Iraq, and of course 9/11 continues to be the probably most significant foreign policy event in U.S. history, at least since the Cuban Missile Crisis. So once again, federal government's taking a much bigger role in foreign policy as well. So this is one of the reasons the federal government's power has increased so much. We get into the 20th century, or mid-20th century, we get the era known as cooperative federalism. And some background here, this is more nation-centered federalism. So the emphasis is going to be on the national government instead of state governments. Probably the key event that led to this was the Great Depression, which you probably know is usually considered to have begun with the stock market crash of 1929, which began the Great Depression. People wanted the federal government to do something about this, to get the economy moving again, to get people working again. And so Franklin Roosevelt elected president in 1932 and on a platform promising a New Deal, which was popular with the public, but certain programs in it, notably the National Relief, the NRA, the National Relief Administration, was struck down by the Supreme Court. Roosevelt proposed a court packing scheme to deal with this. He proposed appointing a new Chief Justice for every current justice over the age of 69, purportedly to take the load off, to give them more help, but in reality to pack the court with his supporters. This didn't end up happening, but a couple of his critics on the court did step down and resign, and beginning in 1937, the Supreme Court starts upholding New Deal programs. During this era, we see the levels of government come to be seen as part of a single system. There's more cooperation here than competition. The feds provide money, states build highways, for example. This continued in the 60s with the New Society programs, as well as the Voting Rights Act of 65. Now, there was some backlash against this. There was some criticism of it. People on the states' rights side of the equation argued that we were creating a federal government that was too powerful. And this backlash is ultimately going to lead to the era known as New Federalism, which would continue up until the 1990s. And Richard Nixon, elected president in 1968, was one of the leaders of this. He began shifting away from categorical grants, which was money earmarked for a special purpose, towards grants that were more open-ended, that could be used for a wider range of projects. This would later become block grants during the Reagan administration. The 90s too, the Republicans win control of Congress for the first time in both houses, I should say, for the first time in 40 years, and they do this on a platform called the Contract with America, which was a platform of 10 promises they made that legislation they would bring to the floor if they were given power or given control of Congress. And several of these dealt with states' rights. One was the repeal of the national speed limit. Working with Clinton, some power was shifted back to the states as well. Welfare rolls, for example, were shifted to the states. Supreme Court under Rehnquist also advanced new federalism. They made it more difficult to sue the government, and shifted some power back to the states, although it was modest. Most of the power still resides with the national government. Should mention unfunded mandates. These are programs that are created by federal law that put standards in place on states that require certain action, but they don't require funding for this. So, for example, and it might be the Clean Air Act or the Clean Water Act. Federal law requires states to enforce these acts, but they don't provide any funding for doing this. Another might be No Child Left Behind. It requires testing, but doesn't provide specific funding for testing. These are Congress likes to pass these because it allows them to do something without having to pay for it. States have to pick up the slack, which means either they raise taxes or cut some other program. Either way, it makes people mad. So they get the blame for it. Congress did eventually pass the Unfunded Mandates Reform Act, which requires Congress to fund mandates unless a majority of both houses vote not to do so. All right, let's talk about state governments here. We mostly talk about the federal government. State governments are diverse. There's a lot of different ways that state governments are designed, although they do mostly have some similarities. All states, for instance, have separate legislative and executive branches. All but one state have a bicameral legislature, which means that they have they have both a House and a Senate. The only exception to this is Nebraska. They only have a one-house legislature. Most governors are limited to 2 consecutive 4-year terms, although there are some exceptions. Virginia, for example, the governor is limited to only 1 term. Wisconsin, there are no term limits, and a governor can serve as long as they keep getting reelected. I think Tommy Thompson served 4 terms or 16 years as governor of Wisconsin. All governors have veto power, but the veto power varies. In Tennessee, the governor has what's called a weak veto, which means that it only takes a simple majority of both houses to override the veto. Simple majority is also what it takes to pass a bill in the first place. So theoretically, if the House and the Senate pass a bill, they have the votes to override it as well. Other states have the 2/3 rule, which means it takes 2/3 of both houses to override a veto. Most governors have what's called a line item veto, and what this means is that the governors can go through each line of the budget or each line of a bill and remove the parts they don't like and then sign the bill, and what's left behind becomes law, but the parts they remove do not. And this is one way that pork barrel expenditures can be dealt with. You could just mark them out. In most states, judges are elected going by what's called the Missouri Plan, which is sort of elected. What this means is that a board of experts recommends candidates for judges. The governor then selects judges from that pool and appoints them, and at the end of their term, they face a retention vote, which means the public votes yes or no on whether or not to leave them in power. And in Tennessee, when we had retention votes, I think only one judge in the history of the state ever failed to win retention. So it's very rare that they don't stay in power. Others, local governments, we should talk about this. These are super diverse, all kinds of different forms of this. Villages, cities, towns, townships, counties, parishes. They don't necessarily consist of 3 branches. Some have 2 branches. Some run all local services, others don't. One of the more interesting ones would be the New England Town Hall meeting, where the entire adult population of a town meets to adopt a budget and then vote on legislation, which is as close as we get to pure democracy, although usually only about 20% of residents actually take part in this. Speaking of democracy, direct democracy. A number of states have certain aspects of direct democracy. One of these is a recall. A recall, which I say governor here, but this could be also state senators or state legislatures. Any elected official in the state can be recalled. What does it mean to recall someone? If you dislike the job that the governor is doing, you can circulate a recall petition. If it gets enough signatures, then it will be put on the ballot for a vote, and if a majority of voters vote to recall the governor is removed from office. This is separate from impeachment because A, impeachment requires action by the legislature, whereas a recall doesn't, and B, impeachment requires the governor to be alleged to have committed a crime, whereas a recall does not. A governor can be recalled for any reason. It's very rare that this happens. I think my most recent example of this was in 2003 when California Governor Gray Davis was recalled and replaced with Arnold Schwarzenegger. Before that, I think it was the 1920s in North Dakota when a governor was recalled. So it doesn't happen very often, but it can happen. It does not happen in Tennessee ever, though, because Tennessee does not have a recall provision in our Constitution. Another thing, which is more common, is the ballot initiative, and this allows citizens to make laws themselves. If you want a law passed, all you have to do is write up the law you want, collect enough signatures. Once it reaches X number of signatures, it is put on the ballot at the next election, and if a majority of the voters vote yes on it, then it becomes law. And these are very common in a number of states. Marijuana, you probably know, is legal in Colorado now. This was the result of a ballot initiative. Tennessee, again, does not have ballot initiatives, though. We do have, in a limited sense, referendums. Sometimes a legislature decides they don't want to decide on whether or not on a law themselves. They would rather let the voters decide on it so they can put it on the ballot for a vote. This can only happen in Tennessee, though, on proposed constitutional amendments. Proposed constitutional amendments have to be approved by a majority of the people who vote for the governor. So Tennessee only has one of these three, and the one we have is only partially. All right, so federalism, public policy, education. Education is certainly more of a state and local government issue than a federal issue, although the feds are getting more involved. Funding comes from local and state governments. States adopt curriculum. The feds, though, provide aid to the schools and regulates them through things like No Child Left Behind. The Department of Education also imposes or requires civil rights to be respected, going back to the Brown versus Board of Education decision. Finally, future of federalism. There's probably, right now, the pendulum might be swinging back a little towards states' rights. I don't think we're ever going to get back to the point we were at in 1790. As long as we have a permanent military, as long as we have Social Security and Medicare, the federal government's going to have to take a more active role. So the states are going to be taking a back seat to that for the foreseeable future. Now, some power, I think, may shift back to the states, and some of it has. What is the appropriate role of state and national government? Who should do what? I'll leave that up to you. That's a normative issue. You can decide what you think and what the appropriate role of each level of government is. And I'm going to call it a day there. As always, if you have any questions, please let me know. Otherwise, I will see you next time. Have a good day.